Hello. Yeah, morning.
Good morning, everyone, and welcome to the second day of the Norman Manley Law School Legal Day Clinic Fair 2023. We have, we're not ready for me yet. 2 presentations scheduled for this morning. Hugh? Good morning, everyone, again. And our first presenter for our second day of the Legal Aid Clinic Fair will be Mr. Hugh Wilson. Mr. Wilson is one of the tutors here at the Norman Manley Law School Legal Aid Clinic. Mr. Wilson comes to us with a wealth of information. My camera is not on. Mr. Wilson comes with us with a wealth of experience, having practiced on both sides of the bar, both on the civil bar and in the criminal bar as well. And we are very pleased to have him make his presentation this morning on habeas corpus applications. Now, we will ask that you place any questions that may arise in the chat on your feed, and we will raise those with Mr. Wilson throughout the presentation or when we get to the end of the presentation, as he indicates. Over to you, Mr. Wilson.
Thank you, Mrs. Bali. I will be presenting on the topic of habeas corpus application in the parish courts. The structure of my presentation will take the following form. Firstly, I will briefly examine the legal and factual context that would give rise to the necessity of applying to the court for a writ of habeas corpus. Secondly, I will then look at the concept of habeas corpus. And thirdly, the procedure used to obtain the writ of habeas corpus. Let us look at the context. One of the overarching duties of the police is to investigate, prevent, and detect crime, apprehend the person who has committed a crime, and to bring that person before the court as soon as is reasonably practicable. Unfortunately, practice has developed in the Jamaica Constabulary Force, whereby the police would arrest and detain a suspect of having committed a crime, and thereafter investigate whether or not the person has in fact committed the crime. Clearly, in such a situation, the person will be detained in custody for an indefinite period of time while the police carry out its investigation. Person charged with a criminal offense is entitled to bail by a court, justice of the peace or the police. And such a person should not be held in custody for longer than 24 hours without the question of bail being considered. If the police detain the person for over 24 hours, such detention will have to be justified. However, where the person arrested or detained is not charged within the 24-hour time frame after such arrest or detention, the police should bring him before a judge or a justice of the peace, who would order that the person be immediately released, or the judge or the justice of the peace may make such order as is appropriate, having regard to the circumstance of the case. However, there's an exception to this general assertion. If the person is arrested or detained pending an identification parade, he should not be brought before the court. In such a situation, the judge may extend the 24-hour limitation period. If the person is detained pending an identification parade, the police must bring evidence to satisfy the judge, justice of the peace, that adequate steps are being taken to expedite the hearing of the identification parade. In such a case, the judge may remand the person for a further period necessary to conduct the parade. In other words, the judge will facilitate the police in holding the identification parade. However, if the judge is not satisfied that it is intended to hold an identification parade for the detained person within a reasonable time, the judge may order that the person detained be brought before the court within 24 hours. Of course, when the person is brought before the court, the judge will then make such order as is appropriate, having regard to the circumstance of the case. Now, if the person is not detained pending an identification parade or is not charged with a criminal offense, he should be released forthwith. Unfortunately, that is not the case, and this is where habeas corpus comes in. What then is habeas corpus? There are various shades of definitions of habeas corpus, but for the purpose of this presentation, habeas corpus will mean produce the body. In this context, the court commands the police to produce the body of the person detained before the court. Therefore, a writ of habeas corpus is issued by a court to inquire into the legality of an arrest or detention of a person. It is based on the principle that the first and primary end of human law is the protection of personal liberty. The Charter of Rights and Fundamental Freedom has enshrined personal liberty as a constitutionally guaranteed right. Clearly, habeas corpus is of fundamental constitutional importance as it protects personal liberty and enforces the rule of law against an agency of the state that has detained a person without demonstrable legal cause or justification. If we briefly look at section 14 of the Charter of Rights, it provides, section 14.1 provides that no person shall be deprived of his liberty except on reasonable ground and in accordance with fair procedure established by law in the following circumstances. One such circumstance is the arrest or detention of the person is for the purpose of bringing him before a competent legal authority on reasonable suspicion that he has committed an offense, or where it is reasonably necessary to prevent him committing an offense. Section 14.3 also states that any person who is arrested or detained shall be brought before the court within a reasonable time. Unfortunately, we have seen in our experience that that has not been the case. If the person arrested or detained is not promptly brought before a court and is therefore being detained without lawful justification or reasonable excuse, the need for habeas corpus arises. And this is where you as young lawyers come in. Before I look at the section, I must point out that the purpose of habeas corpus is to provide a fast, swift, and effective means of challenging cases of illegal detention or arbitrary interference with a person's physical liberty. Because of the primacy the law places on personal liberty, the court must rule on the legality of any arrest or detention without delay, in order that the detainee be released if it finds that the detention is unlawful, unjustifiable, or arbitrary. This is important, and I ask that you note it. The application is made to the court as of right. It is not a discretionary remedy like an injunction. In other words, the court does not have the option to decide whether or not to hear an application. Once an application is made, the court must consider it without delay. Now, Section 286 governs habeas corpus application in the parish court. Section 286 empowers a parish court judge to inquire into the circumstances and reasons for detention of a person who is in prison or confined to any prison and make such order as the circumstances dictates. Having said all of that, how do you go before the court? An application for habeas corpus may be made verbally or in writing. Before a verbal or written application is made, the attorney must first determine and be armed with information concerning the case, including the following information: the name of the investigating officer. Investigating officer is stationed. The date of detention of your client. The offense for which your client is arrested or detained. The length of time your client has been in detention. You will ask the question, where do I get this information? You'll get that information from a family member knowledgeable about the case. If the habeas corpus application is made verbally, the attorney will go to court that date on which the court is sitting and say to the court, Judge, I would like to make a Section 286 application. Because the matter is not before the court, the judge will instruct, and some judges do instruct, the clerk of the courts to list the matter on the court sheet for hearing. The parish judge will then ask the liaison officer, and this is important when you go to court, you have to identify who the liaison officer is for the police division in which the investigating officer is stationed. So the court will ask a liaison officer to contact the investigating officer. Judge will then stand the case down pending the arrival of the investigating officer, or information concerning the matter. Now, you must be prepared to wait the entire day. Or you may wait half a day. Or if you are aggressive in your approach, you may ask the investigating, the liaison officer repeatedly if he or she has contacted the investigating officer. Now, having waited a while, the liaison officer will inform the court. And this is the standard response. The liaison officer will inform the court that the accused, that the person detained is detained pending an identification period. This is invariably the response. Now, what happens in a situation like that is the court will then set a date for the police to conduct the identification period, failing which the person detained would be released. Or the liaison officer may say to the judge, Judge, an identification period is scheduled for tomorrow morning. In which case the judge will say if the period is not held, the person detained should be released on the follow. Let me rephrase that. The judge will then say to the investigating officer, if the ID period is not held on the day the investigating officer said it would be held, then the person should be released. And these are some of the orders that the court will usually give. I should point out to you that a verbal habeas corpus application is cost effective and efficient. And I would commend that approach to you. However, there are some attorneys who give the impression that they have done a whole lot of work. And you will see that reflected in a written habeas corpus application. Now, if the application is in writing, it must be commenced by a notice of application supported by an affidavit. Time-consuming, having regard to the fact that an habeas corpus application should be swift, efficient, and fast. Now, the attorney at law representing the person detained may swear the affidavit, or a family member may do so. The notice of application must be served on the police. The reason why you would have a family member swear the affidavit or the attorney himself swear the affidavit is because you would have to go to the police station where your client is being detained. You'll have to take a statement from your client. You would then have to find a justice of the peace to witness your client's signature. It takes time. Habeas corpus must be fast, swift, and efficient. Now, when the court conducts an habeas corpus application, it will be in the nature of an inter partes hearing. The court will determine whether the writ should be issued. What normally happens is that the police will put forward its ground for detaining the suspect or your client, and the judge will then determine their legality. If the judge decides that they are insufficient or that there is prima facie ground for believing that the detention is unlawful or arbitrary, the writ of habeas corpus will be issued. The detained person will be released and you would have earned your fees. Thank you. The floor is now open for questions, if any.
I am not seeing any questions posted as yet in the chat, Mr. Wilson.
There is one question from the audience.
Go ahead.
Yeah, could you identify yourself, please, and your name? Mark Foster is asking a question. Please go ahead, Mark.
I am not seeing any questions.
Yes. The question Mark is asking is that the person who is detained can apply for bail. But normally the person applying for bail wouldn't have any money or any surety to be released from custody. That's what you're saying, Mark. But that is not habeas corpus. Bail is granted. It is not because of anything that the police has done, but it's because of the impecuniosity of your client while he's there. But in a situation like that, what the attorney usually does is to ask the judge to reduce the bail. So, for example, if the bail is 100,000 and the person has been in custody for 1 month, by reason of the fact that he has been unable to take up his bail, the attorney would say to the court, Judge, these are the circumstances. Could you reduce it to 50,000 with 1 or 2 surety? And if the person has not taken up his bail, the attorney will go back before the court and say, Judge, he has not taken up his bail because he could not find anybody to bail him. Could you reduce it to 25,000 with 1 or 2 surety? Yeah. Mrs. Valley, are there any questions coming from your side?
I'm still not seeing any questions as yet, but a question occurred to me during the course of your presentation. Now, from my understanding of what you said, habeas corpus applications can be made when someone has been detained by the police. Does that also apply in instances which we have now where persons are detained under the states of emergency or in a zone of special operation? Would the same procedure apply?
No, there are special provisions on emergency powers regulations. There are special powers that the police have in relation to arrest and detention. You can be held in custody up until the end of the state of emergency, or if you have been in custody for 3 months, then the police will bring you before the court for bail to be considered. So there's a different regime that would cover it. What I've just presented on is in the normal course of things. That is what should happen. Under the state of emergency, they have a different regime.
For that response, Mr. Wilson, I have another question. And it says, can you use a habeas corpus application when you can't find your arrested relative?
You can, if that's the case, and it is due to if you suspect that the police has detained your person, detained your client, and you do not know where, you can approach the court to ask the court to produce the body. That's what habeas corpus application is, to produce the body before the court so that the court can determine the legality of the arrest. But that's a very good question, Mrs. Bali, because our experience has been that the police would oftentimes detain a person, move the person out of the jurisdiction in order to frustrate family members from locating him, or the attorney making an application on his behalf for bail. So an habeas corpus application I would definitely use for such a situation, yes.
Thank you for that response. I see another question being posed in the chat. It says, well, I'll read the entire comment as well as the question. It says, good morning, it's an excellent presentation. Do you see a potential clash between the rules governing habeas corpus and the proposed pre-arrest detention currently being considered? I believe this is under the terms of the new Bail Act.
There would definitely be such a potential clash that lawyers will have to challenge. An habeas corpus application is of vital constitutional importance. One will have to examine that. There is, and the answer is yes, there's a potential clash.
And
But
just
one question here, Mrs. Bali.
sorry. Go ahead.
If you are detained or arrested on a warrant because of a failure to pay a traffic ticket in another parish, the Friday before public holiday, Monday, and not taken before the court, Tuesday, Wednesday, under what circumstances could habeas corpus be made? You can, if you can make the application on Tuesday morning or Wednesday. Yes. If Tuesday is the first sitting, then you will go to court on Tuesday. And if your client is not before the court, then you ask the judge to make the appropriate order in the circumstances. And you put yourself in a position so that you can pay the traffic tickets. If there are no other questions, Mrs. Bali.
Any further questions being posted in the chat? And I'm not sure if your audience or if your live audience has any further questions at this time.
Yeah, there's one.
Go ahead with that question.
Let me use the question that is posed earlier. Assuming that she goes before the court on Tuesday and the client is not, or the suspect or her client is not before the court on Tuesday, you will ask the court to issue an order that it be brought before the court on the following day. And the person is not brought before the court on the following day, that would be Wednesday. Thursday would be a reasonable time. After that, you raise hell. If there are no further questions, Mrs. Bali, I would like to.
And when you say you raise hell for the benefits of the students who are.
So what I mean is one studio audience was asking if you strip naked before the judge. No, you become very firm, assertive, and play the role of an efficient lawyer. That's what I mean. I see Mr. Davis here, and when Mr. Davis was a young lawyer, he was a very firm, no nonsense, and passionate advocate. And that's what I'm saying, Mrs. Bali. If there are no further questions, I'd like to thank you for listening. And for the Norman Manley Law School students, if you have any further questions that you'd want to raise with me, I'll be more than willing to answer those questions. Thank you.
Thank you, Mr. Wilson. Certainly we have benefited from an insightful and, as usual, practical presentation on what what one is to do when it is that persons have been detained without being charged. We had invited Miss Maria Nemhard to move the vote of thanks. I'm not sure if she's currently on the platform. Okay, in the absence of her being present, I want to take this opportunity, Mr. Wilson, to say a hearty thank you on behalf of the Norman Manley Law School, the Legal Aid Clinic, as well as the students and staff who are here present this morning, for participating in our legal aid fair with the topic dealing with habeas corpus applications. I found the presentation this morning, as usual, to be very valuable and filled with nuggets as to how one is to approach situations such as these. We want to say thank you and well wishes as we move forward for the rest of today.
And thank you, Mrs. Bali. The pleasure was all mine.
I think this brings us to the end of the first session for today. In the absence of any further questions or comments, the fair continues later today with our second presentation, which is scheduled for 10 o'clock. So we'd ask that participants, you join us at that time for our second presentation for this day 2 of our legal aid fair.
Before you go, Mrs. Bali, a slight correction. It's at 11.
11. Thank you very much, Mr. Wilson. So please rejoin us. Those of us who are on the platform, please rejoin us at 11 o'clock this morning when we will be treating with a presentation, one moment, please. Presentation that will be treating with the right to counsel and the role of duty counsel, which is also going to be particularly insightful for young attorneys and even those who may find that they need to have counsel when they find themselves being detained by police or other agents of the state. So we look forward to that presentation at that time. Please join us then.